Yes, hello everyone. I'm Stephen Stern, partner in the law firm of David Dow, Siegel and Stern, proud to bring you Senior Counsel here on LI News Radio. If you have questions regarding elder law estate planning, give us a call at 631-234-3030. That's 631-234-3030. David Dow, Siegel and Stern, Long Island's elder law, special needs and estate planning firm, where the best advice leads to lasting solutions. And to tell you, this past week, have heard of so many deaths in our community among family and friends and acquaintances. Some have been grandparents of friends. Some have been friends of friends, those that are in their mid-40s. And in our practice at David Dow, Siegel and Stern, of course, we deal with death and dying and incapacity and how to plan for that on a daily basis. But when you see it and hear about it out in the community, of course, we all have to look to ourselves. It's time to look in the mirror and ask ourselves if that was us in our situation, with our families, with the things that we want to accomplish, all the things that are so important to us, would we be prepared, especially if you're in your mid-40s and you pass away suddenly. We have responsibilities to ourselves, to our families, to make sure that plans are in place. And as an elder law and estate planning attorney, I'm often asked by my senior clients why they need to be concerned with estate planning. Isn't that only an important issue for the wealthy? And after all, I still feel young, I still feel healthy, so why do I even need to think about it now? And for someone who is in their 70s or 80s or 90s and still looking good and feeling good, so many times we see people who are also looking good and feeling good who are a lot younger, who are passing away. So obviously this is something that applies to all of us and can strike any of us and any of our families at any time. Obviously, you don't need to be rich to consider estate planning. And unfortunately, once you do get sick, you may no longer be able to do estate planning. Obviously, when you pass away, all of the opportunity is gone. And so estate planning, sooner rather than later, is really necessary for each and every one of us. And estate planning is really all about getting your assets to the people who you want them to go to. Of course, taxes, probate, ongoing trusts for the benefit of a child or a grandchild, that's all a part of it. But the ultimate goal of planning an estate really is to get your assets to the people who you want them to go to. Now, if you can do that quickly, if you can do that cost efficiently, that's even better. But if not planned in advance, there's really no way to control how your estate will pass. And in fact, if you don't have an estate plan in place and your assets aren't structured in a way that will dictate where they go and who they go to, then New York State will give you one. New York State is going to make sure that you have a will. It's just going to be done through New York State's intestacy laws. And that scheme of distribution may not even come close to what your real wishes are. People will ask me that all the time. Well, what if I don't have a will? What if I don't go through the process of doing it? What if I don't sit down with a lawyer and have one drafted? So what? How's it going to go? It's still going to go to my family, isn't it? Well, it's going to go to some family, but it's going to go according to the laws of the state of New York. And that may not be the way you want it to go. In fact, I've probably seen the majority of times where it wouldn't go the way that someone would want. Rather the division to family members when you're still relatively young, and later on, perhaps in your own life where family members have passed away, maybe now you're talking about your side of the family along with your spouse's side of the family. Family now starts to mean something very different later on than it might have in your earlier years, and you might not want to see a good portion of all of the assets that you've worked an entire lifetime for to go to family members that you don't necessarily want them to go to. Now, a will Right? A last will and testament controls where and how your assets are transferred on your death. And a well-drafted will can provide for ongoing financial needs of a loved one, can create continuing trusts for the benefit of family members, particularly children or grandchildren with special needs. A will, the language within a will can establish professional management of estate assets, and a will should structure the estate in order to minimize or even eliminate estate taxes. And we've talked about estate taxes here on Senior Counsel in the past, is the kind of thing that many of us need to be concerned about. Many of us now don't need to be concerned or as concerned about estate taxes, given the change particularly with the New York State estate tax, and we've discussed that in the past. Still very important to know how new estate tax laws will affect you and your family and your estate. But the language of a last will and testament should be structured so that estate taxes can be minimized or even eliminated. But these goals can really only be accomplished if the plan is actually done. You can think about it all day long. You can even write down some notes on a piece of yellow pad paper or on the back of a napkin, but the plan can really only be accomplished if it's actually done. You can't just give it some thought. You actually have to do it. And along with a last will and testament, other important documents should be considered as well. Trusts for the benefit of minor beneficiaries should be considered. Special types of trusts for managing assets upon incapacity and avoiding probate, which we're going to discuss in greater depth in a moment. And of course, it's crucial to have important documents like a durable power of attorney, a health care proxy, a living will. These are important documents for anybody at any age, really, to have in place. In the event you get sick and you're not able to pay the bills, write the checks, who's going to make those important decisions? Who's going to have the authority to write checks and pay the bills and get insurance information if you're not able to? If you're not able to communicate with your doctors about health care choices, who has the authority to do that? The documents that you put in place to do that are the health care proxy, which gives someone the authority, the power to do it, and the living will, which can serve as a document that gives the guidance as to how to make decisions. How do you feel about death and dying? What kind of treatment would you want or not want given the situation? This is the place where you can talk about your healthcare wishes, artificial nutrition and hydration. Would you want the tubes? Would you want the food and the water to be kept alive by artificial means? And under what type of circumstances would that be? Or are you someone who is very committed to the idea that you don't want the tubes? You don't want to be kept alive by artificial measures? What kind of burial instructions would you like to leave? These are all the kinds of concerns that my senior citizen clients have, but really all of us should have, regardless of age, regardless of health. These are the things that we all need to start thinking about and take the necessary steps sooner rather than later. In our office, we handle an awful lot of guardianship matters. Guardianship matters where you have to go to court to prove that someone is incapacitated and in need of a legal guardian to make any important financial or medical decisions, personal property, personal management, personal needs decisions. And I can tell you that it is much better, much simpler, and really just a lot more pleasant to be able to conduct what could be very difficult tasks simply by having important documents in place, a power of attorney, a durable power of attorney, a healthcare proxy, a living will, rather than having to go to court, make the case that someone is incapacitated and now in need of a legal guardian, and now to have to deal with a court process, court jurisdiction for the rest of someone's life. The choice is pretty clear, really. Doing simple documents like a power of attorney, a healthcare proxy, and a living will, or, on the other hand, having to deal with the court system and the lawyers and the attorney fees that go along with it, for what could be many, many years to come. The important point here is that everyone needs to consider estate planning. Some require only simple plans, others might need something more sophisticated. But young or old, rich or modest, we all need to be concerned with planning our estates. The time to do that is now, before there comes a time where it may be too late. Questions regarding elder law and estate planning, give us a call at David Dow, Siegel & Stern. Telephone number is 631-234-3030. That's 631-234-3030, or you can get us on the web at www.daviddowlaw.com. I'm Stephen Stern, partner in the law firm of David Dow, Siegel & Stern, proud to bring you senior counsel here on LI News Radio, and we'll be back in a bit. Will ask, if I have a will, does that mean that I need to go through the probate court process? Because I've heard that probate is something to be avoided. I want to stay out of the probate court. If I do a will I need to go into probate? And the answer there is yes. Yes, in fact, that's exactly what that means. Because when you have a will might be a good-looking document. It could be 5 pages long. It could be 25 pages long. It could be 100 pages long, and a true work of art. But ultimately, a will is really just a piece of paper. It's a piece of paper that's important to have, but it doesn't really mean all that much until two things happen. Number one, of course, you have to die, unfortunately. And number two, the will then is only really given its validity when it is admitted to probate, the probate court process. And that means that upon someone's passing, you have to take the will, you have to go before the probate court. And in New York, that's called the surrogates court. You have to go before the court. The court has to take a look at it and say, yes, it looks like it was properly drafted, it was properly witnessed and executed, and now an executor can be appointed and given the authority to gather up all of the assets, make distribution in accordance with the terms of the will, and file an accounting and wrap up the estate. And what I said in the last 12 seconds, in real life, can take many months. It can, even in sophisticated situations or where there might be a contest involved, can take many years to go through before an estate is wrapped up. Now, avoiding probate for everybody is not necessarily something that applies. And in fact, there might be situations where you do want to go into probate. But for many others, avoiding the probate court process is something that should at least be considered. And one way that becoming more and more popular is the use of a special type of a trust. A revocable living trust is a term that many of us and more of us are becoming familiar with. And it's become very popular, particularly among the elderly. Many believe that a revocable living trust will work to reduce or eliminate estate tax. Others are under the impression that it will protect assets in the event you need nursing home care to protect our assets from the high cost of long-term care. And there are still others that think if they have a trust that there's no need for a will. And there's a lot of misinformation out there, a lot of misinformation, particularly within the senior community. So it's crucial that as an elder law and estate planning practitioner, that we make our clients familiar with the advantage and the disadvantages of using a revocable living trust as a part of an overall estate plan. It's also important that if you have a revocable trust already, that you have it reviewed from time to time to make sure that it will actually meet your goals. And that's particularly important because what the goals might have been years ago might change over time. Perhaps in the past, when you're relatively younger, it's about providing for children or grandchildren. Now, as you get older and maybe illness and incapacity becomes an issue, protecting your assets might become an issue. And perhaps now even avoiding or minimizing the estate tax is a top goal. And so even if there was a trust done in the past, it's important to make sure that you take a look at it and have it reviewed to see that it will meet the goals as they currently exist. But ultimately, the client might determine that a revocable living trust is appropriate. And there are several advantages. There is a lot of good that goes along with a revocable living trust. Avoiding probate, of course, is the big one. And today, particularly seniors have heard that one of the most important concerns in estate planning is to avoid probate. That's what they hear. They hear it from their family. They hear it from their friends. They learn about the problems of probate from financial professionals and their accountants. And of course, they read about it. We all read about it in the newspapers and other publications and the ads that we see for revocable living trust seminars. And it's also possible that someone is already experienced the probate process in regard to an estate of a close family member, and so they know. They know about the time and the expense and perhaps some of the judicial impediments that can go along with it. Privacy becomes a big issue for many, and there's no requirement that a person be rich and famous to want privacy. To some degree, we all want to maintain our dignity, our independence, and our privacy, and many seniors don't want their estates to be made public. That's what the probate court process is. They may not want the public to know which heir receives what property. As a private contract, a revocable trust is not a public document. And then, depending on the circumstances, it might not be subject to inspection by the courts or the general public. Again, that's not necessarily something that applies to everybody, but it does apply to many, making sure that their estates are kept private. A use of revocable living trust might also be appropriate where you have property in more than one state, where a trust holds real property located in a jurisdiction different from where the creator of the trust resides. Then title to property continues to be held by the trust upon the creator's death. So therefore, there'll be no need for an ancillary probate in another state. And so many of the families that I work with will consider their primary residence in New York, but they'll also have that condominium down in Florida. They might own vacant property in North Carolina or Texas. Many of other assets out in Arizona and points west. Well, if you avoid probate in one state, then you have the opportunity to avoid probate in all the other states as well, as long as it's properly structured. And so certainly, if you have property in more than one state, then a revocable living trust might be an appropriate way to go. Is it right for everybody? Not necessarily. Does everybody need to avoid probate? Perhaps not. But everybody should be considering their own estate plan and how these particular options might be appropriate given their specific set of circumstances. Questions regarding elder law and estate planning and how it applies to you? Give me a call at David Dow, Siegel & Stern, 631-234-3030. That's 631-234-3030. I'm Stephen Stern, proud to bring you Senior Counsel here on LI News Radio, and we look forward to speaking with you next time.